Okay, good morning, everyone. I'm Dick Kelly, and with me is Evan Smith. We're both of the Chemical Practice Group at Oblon. And we have a little housekeeping to do. If you have questions, you can use the chat function that I'm told is found at the balloon in the lower right-hand portion of the screen. If possible, we'll reply during the webinar or at the end of the program. As far as taking notes about the slides, we will be sending a copy to all attendees, and a replay, if this is found exciting, will be available on our website. And what we're talking about, of course, is listing medical devices in the Orange Book after Teva v. Amneal. And really what this is all about is life cycle management. It's a term of art that's fallen out of use, but people are using the technique to try and extend the monopoly period, or let's see, exclusivity period, to be a little nicer word, for their products. And it's in particular, it's directed to combination products. Now, combination products are defined by the FDA as basically you're combining at least two components, one selected from drugs, devices, and or biological properties. And combination products are exemplified in the FDA website as being a drug-device combination. And that's what's at stake in the Teva Amneal litigation and decision, but they can all be a biological device combination. And one of the examples the FDA gives is drug-eluting stents. Now, those aren't too exciting because that's going to be controlled by the doctor, and you're not talking about buying the drug at the drugstore, which is the usual place that you're concerned with. Now, a drug-biologic combination is also possible, such as a vaccine with an adjuvant. But here, the likelihood is that you will get an approval from the FDA and your patents will be to the combination. Now, you can have a drug-device biologic combination, and that's another possibility. But there you have, this will be something like the antibody-drug conjugates. But generally, for antibody-drug conjugates, the patent claims are going to be claiming the entire thing. But what you can do is you can list that because of the drug component in the Orange Book and get the benefit of the Orange Book. Now, the benefit to the Orange Book is that if somebody files for your combination, the drug is going to show up along with the combination in the Orange Book if you list it, and any generic will have to give you notice and the certifications that are required. And possibly this will get you into the ability to have a 30-month stay of the approval process. Now, combination products can also include separate products packaged together in a single package or unit, such as a kit, or they can even be separate products, such as a drug which is activated by a particular wavelength of light, and you have a light source to do that. The key in that case is the products are labeled to be used together to achieve a therapeutic effect. And that's the whole game that's going on here, is labeling is going to be important. Now, when you talk about the combination of a drug with an applicator or a medical device, you're probably going to say, well, medical devices, I can design around those. It's a mechanical device and it should be pretty easy. But the problem is that this is 2 pages from the Wegovy label of the Novo Nordisk product. And you'll see that the label has on it the injector pen, how it's used, and you also have this picture of how you shouldn't use it. And the generic label must have the same pages. In fact, the generic label must be identical to the reference listed drug label, except for the notation as to who's the manufacturer and any telephone numbers to call if you have a problem. So a generic wanting to make a copy of Wegovy has to match the injector pen human-patient interface operations. The indicator as to how much drug has been injected must be the same. The injector activating mechanism at the top to press down and ultimately release all has to be the same, because the patient is basically using the Wegovy instructions to activate the generic device. Now, on injector pens, this might not be so exciting, but if you're talking about a rescue inhaler, for example, which is one of the big areas, the inhaler has to work the same as the reference listed drug. It has to work off of the label from the reference listed drug. The only things that you can change in either an injector pen or inhaler are internals. And for instance, the counter could be probably activated somewhat differently so long as the patient doesn't notice any difference. And if you took any look at the Teva case, you'll find that Teva had, I think in that case involved 5 patents. All 5 of them were directed to the mechanism for indexing how many doses were left. Okay, an important thing for the user. Now, to give you some idea of the importance of having it in the Orange Book, the medical device, according to numbers the FDA has and put in their amicus brief, manufacturers earned approximately $180 billion on inhalers in the 20-year period between 2000 and 2021. Of that, $67 billion, or about $3 billion a year, were from during the period where what they call the primary patent was in place. And the primary patent they're talking about is the patent on the active pharmaceutical ingredient that the inhaler dispenses. Secondary patents, which are considered to be the device patents, it was about 62% of the total sales, $110 billion. So you can see that having the medical device patent in the Orange Book gives you a tremendous tail on your sales. You're protecting the market after the drug has expired. Now, quite often what you will have is the drug will go through the development phase, and only when it's apparent that it's probably going to be successful will the medical device be developed. And so the medical devices patenting will tail behind that for the drug by anywhere from 6 to 7 years, maybe more, because the device patents, device approvals, at the FDA are pretty quick. What they're going to look for is repeatability of dosing of the device. These are not what one would call devices that are affecting life. Now, obviously, if it's a rescue inhaler, they're going to be a little more careful, but you're kind of starting off with a product, a exclusivity period that's going to be roughly 6 to 7 years longer than if you only had a patent on the drug substance itself. Now, what you have is you have to list in the Orange Book. And there's a statute for that. And what drug companies have claimed is confusion as to which patents could be listed in the Orange Book. For instance, could you list patents on the device where it was a device-only patent, but it covered possible variants of your device and your RLD product? Or could you only list patents which claimed the device plus the drug? Now, this is a little surprising that there was confusion, because the statute itself specifies what is listed. It says you got to list each patent for which a range of infringement could be reasonably asserted. Now, infringement, there's no question but that if you've got a patent that covers the medical device, that could reasonably be asserted in an infringement action. But that's not the end of the statute. It said, and that claims the drug for which applicants submitted the application and is a drug substance patent or a drug product patent. Now, drug substance patents, drug substance and drug product are terms of art at the FDA. And the drug substance is the active pharmaceutical ingredient, while the drug product is the formulated ingredient. And this is a statute again. Now, 2020 is important because the statute changed, as you can guess. Now, prior to 2020, the FDA in 2003, when it was revamping the statutes regarding the 30-month stay period, prior to that, you could get multiple 30-month stays, one for each patent that you had in the Orange Book. And what people would do would be they would add patents as they went along. And so when you had generic first filed, he was facing a 30-month stay for patent 1. Patent 2 is put in the Orange Book, and suddenly he's got a new 30-month stay, and so on. And with paroxetine, what they were able to do, Glaxo, was actually get about 5 years, of regulatory exclusivity in effect beyond the original expiration date. Now, what the FDA did is in 2003, in response to questions from industry, it provided in the Federal Register a notice that the statute was to be interpreted to require that the patent being submitted claims the finished dosage form of the approved drug product. A finished dosage form is specific. That requires the formulated product. Now, the FDA's advice, despite having been requested by industry, has been ignored. And the ignoring was not overlooked. So in 2020, we have the Orange Book Transparency Act, and it has conveniently known as OBTA, and they modified the statute to insert after drug substance what its definition is, active ingredient and drug product. They again inserted its definition, formulation, or composition. Now, what the 2020 Act did was it confirmed the FDA's interpretation. So there wasn't too much doubt as to what was required. Now, the Orange Book appendix lists current dosage forms for approved drug products. This list includes metered aerosols, metered sprays, refill drug delivery systems, which would include
Chinese case for Vigo, and there's an annuity due. It's not in our annuity system. It's due in April. Should I just tell them to pay it?
No devotionals in Vigo.
Sorry, I didn't understand that.
Apologies, I don't believe that was for us, sorry. If it was,
Okay.
Thelma, would you mind unmuting yourself and then perhaps asking again or including it in the chat?
Well, so currently, what you have for listable patents are any patents which contain at least one claim where the approved drug is a limitation, and that's the approved formulation, or they're a little bit looser with the statute than the FDA was in the interpretation. It could be the active pharmaceutical ingredient. Now, a Marcuse group, if it's not overly large, should be acceptable. Now, such a patent doesn't have to be limited. The claims don't have to all be limited to the approved drug. Simply one a claim has to be so limited. So, for example, you could have a patent with a series of claims defining the device, and then you would add at the end, perhaps, the device of claim 1, which also comprises the listed drug. And so when you look at the case law, you're going to see the FDA approval is not for the device alone, but for the combination of the drug and the device. And now Evan's going to take over and hit the case law as to what's happening. Evan?
Sounds good. Thank you. Just one moment as I take over the presentation. Share. All right. So now to take a look at some of the Federal Circuit jurisprudence surrounding the listing requirement. I think it's worth noting here that despite some perceived confusion in the industry and amongst the district courts about the listing requirement, the appeals courts of the Federal Circuit have consistently come down on the same side of this issue, generally agreeing with the FDA interpretation and the later legislative changes. I think the clearest articulation of the listing requirement and some of the consequences associated with improper listing can be seen in the First Circuit's In Re Lantis opinion. So as a little bit of background, Sanofi manufactured Lantis, which was an insulin product, and it had been properly patented and properly listed as a drug substance in and of itself. And towards the end of the life of the patent, Sanofi developed the SoloStar injector pen to deliver Lantis. And they obtained a patent, the 864 patent, for the injector mechanism of the pen. And they listed that injector pen patent, this 864 patent, in the Orange Book. And so they were subsequently sued in district court by consumers of the product under the Sherman Antitrust Act. And they alleged that Sanofi had improperly listed the 864 patent and obstructed a generic from entering the market. And this had created artificially high prices, and this had harmed consumers. And Sanofi alleged two things in response to this. First and foremost, that their interpretation of the listing requirement was such that the injector pen patent, even if it didn't contain any claims directed to the active pharmaceutical ingredient, was still properly listed in the Orange Book. And they argued that even if they were incorrect about this interpretation, their interpretation was still sufficiently reasonable to defeat an allegation of monopolization and untoward business practices. But it's important to note here that the 864 patent did not actually cover the SoloStar injector pen, nor did it have any claims that included Lantus or any other drug product at all. The patent was purely directed towards the injector mechanism that actually delivered insulin through the body of the pen. And so while the district court didn't take an opinion or didn't render an opinion about the whether or not it had been properly listed, they said it was just sufficiently reasonable. The First Circuit disagreed on all counts. They overturned. First and foremost, they said that under the Sherman and Clayton Antitrust Acts, a reasonable interpretation of the listing requirement is not a defense. So if a patent is improperly listed, it constitutes an antitrust violation. And that's extremely important in the context of pharmaceutical drugs in particular, because while it's generally very difficult to prove antitrust harms, in pharmaceutical cases, the market is the brand name drug labels. And so the market is already established, which makes it easier to prove. And it's also an enormous slice. And on top of that, antitrust actions carry treble damages, or 3 times the damages in question. So successful antitrust suits in this improperly listed Orange Book patents are extremely consequential. And then they took a look at Sanofi's arguments, and they disagreed once again on all counts. They said, even if we buy Sanofi's interpretation of the listing requirement, that it's appropriate to list just the injector pen as a drug product in the Orange Book, that still doesn't apply to this fact pattern, because the patent, the 864 patent, was only to the injector mechanism. And they made an analogy to a transmission in a vehicle, and they said, there's long established United States case law which clearly articulates that a patent only covers that which it literally claims. It doesn't cover anything else. And so a patent for the transmission of a car in no way covers the car itself. It only covers the transmission. And so even if the 864 patent, had it covered the car, would be properly listed, the 864 patent wasn't. It was just to the transmission. And so regardless of whether or not Sanofi's interpretation of the listing requirement was correct, the 864 patent was improperly listed. But they went beyond this, and they said that it would have been improper to list it even had the 864 patent covered the injector pen, because the patent need to have, quote, claimed the drug for which the applicant submitted the supplemental new drug application. The 864 patent did not claim insulin, it didn't claim the Lantus product, nor did it claim any other active pharmaceutical ingredient for which the supplemental new drug application was submitted, and therefore the 864 patent did not claim the drug and was improperly listed. In the same vein, we have the Second Circuit's opinion in United Food and Commercial Workers et al. V. Takeda, and here we have the diabetes drug Actos, the active pharmaceutical ingredient of which piogelatazone, I believe. And here we had a properly listed patent for the active pharmaceutical ingredient owned by Takeda. And towards, once again, the end of the life of the patent, they went out and they secured intellectual property rights to 2 combination patents. And these are patents which claimed this active pharmaceutical ingredient in use with another pharmaceutical ingredient to treat diabetes. And they listed these patents in the Orange Book as being directed towards Actos. And they made a representation to the FDA that these combination patents functionally claimed Actos because they covered the active ingredient of Actos. And once again, we had group purchasers of Actos bring a class action lawsuit against Takeda alleging an improper listing, and that the amount of time between when a generic could have entered the market and subsequently was able to enter the market constituted harms to the consumers in the form of increased drug prices. And Takeda moved to dismiss with 2 allegations. One, that the listings were in fact proper because the active pharmaceutical ingredient was literally present within the claims of these newly listed patents. And 2, that the plaintiffs had failed to allege that the interpretation of the listing requirement was unreasonable, and this was a fatal pleading. The district court denied on both counts, and an interlocutory appeal was instituted to the Second Circuit. And here the Second Circuit affirmed this denial. First and foremost, the Sherman Antitrust Act claims were sufficiently pled through a mere allegation of improper listing, and they pointed to the First Circuit opinion. And more importantly, combination drug patents. So these patents for the active pharmaceutical ingredient of Actos and another drug substance do not claim any of their component substances past the individual patent expiration dates. And so once the original Actos patent terminated, these combination drug patents were then improperly listed. So there was a period of time after these two combination patents were listed in the Orange Book, but before the original patent had actually expired, where these patents were properly listed. But as soon as that original API patent expired, these two secondary patents became improperly listed. And so from that point until the point where a generic did enter the market, antitrust harms had actually attached. And then the Federal Circuit, Court of Appeals to the Federal Circuit weighed in with the Teva case that Dick was describing at the top of the presentation. And this is the same fact pattern, more or less, as the first case I described, where Teva had a patent for this albuterol sulfate inhaler drug product, which was properly listed in the Orange Book. And towards the end of the life of that patent, they went out and they got 5 patents directed towards a metered inhaler counting mechanism. So that's the little ticker on the back of the inhaler, which through each sequential depression of the cylinder counts down from 200 so you know how many puffs you have remaining. And all 5 of these patents were directed merely to that counting mechanism. None of them claimed the inhaler itself, nor did they claim, more importantly, any active pharmaceutical ingredient, let alone the albuterol sulfate, which was actually in the ProAir inhaler product. And the Federal Circuit affirmed or their ruling was consistent with the First and Second Circuit's interpretations that this was an improper listing because the active pharmaceutical ingredient at question here was not actually claimed by any of these patents. And the court in Teva expounded significantly on the relevant case law. They provided some of the clearer interpretations that Dick provided at the top of the presentation. But Teva generally is the cornerstone case that really draws a bright line on what you can and cannot list. So this begs the question of how patents should be drafted if we want to avoid these antitrust suits, because in the context of pharmaceutical drugs, where the market is the brand name and the harms, there's treble damages that can attach. We're talking about hundreds of millions, if not billions of dollars. So we want to be very, very certain that only patents which are properly listed actually make their way into the Orange Book. And to do that, it's relatively simple. When you draft a new patent to a combination drug product and delivery mechanism, a metered inhaler, an injectable pen, whatever it is, just make sure that the specification describes this active pharmaceutical ingredient in question, and that at least one claim in the patent is directed to the combination product. So for example, for Teva, such a claim could have been the inhaler of claim 1 further comprising the albuterol sulfate, or whatever it is, just making sure that you have the actual API referenced in combination with the inhaler or the whatever the delivery mechanism actually is. It's a little trickier, however, when you already have patents listed in the Orange Book and you don't want to risk withdrawing them and allowing a generic to come in prematurely. And so if you are in a circumstance where you don't have any active pharmaceutical ingredient listed in the specification of the patent, generally our recommendation would be to consider withdrawing that listing. and biting the bullet on this one, because there's nothing you can really do to subsequently cure the fact that this patent makes no claim to the API. The jurisprudence is very clear about what you can and can't list now. And it's very important that we withdraw this to prevent future damage associated with monopolization, keeping in mind that this does not retroactively cure any damages that may have been incurred during the period where it was improperly listed. But a slightly better situation we might find ourselves in is one in which the patent is improperly listed because the claims aren't directed to the active pharmaceutical ingredient, but the specification describes the API. And in that fact pattern, we can fix this. You can withdraw the patent from the Orange Book temporarily. You can file for a narrowing reissue with the United States Patent and Trademark Office to add a new limitation which claims the active pharmaceutical ingredient in combination with the delivery mechanism. And then you can just relist it in the Orange Book. And the only downside to this is during the period of time where the patent is not listed, a generic company could come in and establish intervening rights. But given the amount of time it takes to actually get FDA approval and have things spun up, as long as you act quickly, this is relatively unlikely.
Just one thing, Evan, you actually do not withdraw the patent until the reissue issues, and then you withdraw it and substitute. And the big risk is intervening rights during the period that you didn't have your reissue and issued. The other thing is to bring up to date on what the Teva cases are going on. On Monday, the Federal Circuit denied Teva's petition for rehearing en banc, not too surprising. And Teva did move the court for a stay of the mandate, which a decision should come down on that within a fairly short amount of time. So when you're thinking about doing a reissue, you sequence it so that you keep the patent in the Orange Book. And once that patent, you've got your reissue issued, you simply withdraw it, which is a very simple act of sending the FDA. You notice that, hey, here's a reissue to list, and by the way, I want to withdraw the original patent, which the reissue has replaced. Now, I want to stress the other thing is, while we've talked about basically simple combination patents, they could include combination patents for therapeutic uses, combination patents for diagnostic uses, and as I said, they could be combinations where the individual components are individually packaged, but with instructions to be used together. And if anyone has any questions, feel free to either contact Devin or myself. Our email addresses are on the slides. And if you don't want to wait till you get copies of the slides, it's real simple. At Oblong, every email has the same pattern. The initial of the first name, my case would be R, and the last name, Kelly, at oblong.com. And the same for Evan E. Smith at oblong.com. And we thank you for your attendance and your attention. And we wish everyone a good day.